Hello, welcome to Legalese. Legalese is a presentation of the Northern Middlesex Bar Association designed to bring topics of interest in a legal nature to the community. My name is Christopher Lilly. I'm your host. We're joined by two esteemed attorneys who are experts in the field of operating under the influence. And we're dealing today with the issue of a challenge to the breathalyzer, dealing with some challenges that have happened to the breathalyzer that have spanned the entire Commonwealth of Massachusetts. My two guests are to my far right, Michael Bowser, who has offices in Chelmsford and in Nashua. Welcome, Michael.
Thank you. Nice to be here.
Thank you. And Stephen Valancourt is returning, having been on this show at a previous time when we were talking about the breathalyzer. Stephen has offices in Fitchburg.
Yes.
Yes. And he practices, both practice throughout the Commonwealth. I know, Michael, you practice in New Hampshire as well.
As does Steve.
As does Steve.
Yeah.
All right. I don't, so I don't bump into you guys in New Hampshire, but I see you quite a bit in Massachusetts. So Steve, when you were last here, we talked about, I think we were just coming off of the Camblin case, which had dealt with challenges to the breathalyzer Draeger 77110, which is the older version of the breathalyzer. And as a result of that, there have been challenges, or as part of that, now there's been a challenge to the 9510, which is the current version, correct?
Yeah, that's right. When we last sat down and discussed this, there had been a case that had come down where the defendants throughout Massachusetts had challenged the reliability of the breath test machine that was being utilized at that time. Mm-hmm. And then based upon that decision is the Camblin decision that you referenced. Many of us amongst the defense bar decided to raise sort of the same challenges with respect to the current machine that's utilized here in Massachusetts, which is known as the Alcatest 9510. It's made by the same manufacturer, and a lot of the same issues were at play, but there are also differences between the two machines, and so it gave us the opportunity to explore those challenges as well.
Okay. And Michael, you brought one of the original motions that led to this, correct?
Right. So when the Camblin decision came down, the SJC, the Supreme Judicial Court in Massachusetts, said that a defendant facing a breathalyzer case before a jury in a district court was able to challenge the scientific reliability of the machine and the software that ran it. By the time that decision came down in 2014, June, the 7110 was no longer being utilized, the 9510 was. Well, then every defense attorney that had a 9510 breath test case looked at Camblin and said, well, if they can challenge the software on the machine that no longer exists, we should be challenging the software, the reliability, the protocols of the machine that's being utilized today. It's just a newer version of a similar machine, just like a vehicle, like a Lexus ES300. Mm-hmm. Now they're using the Lexus 300 or 330. Similar technology, but some differences that made it a unique challenge. So everyone, myself included, Steve, many lawyers across the Commonwealth, filed what's called a Daubert-Lanigan motion, asking the judge in any particular district court to hold the hearing to decide whether this machine was scientifically reliable, which requires expert witnesses, toxicologists, computer experts, and when the court realized, the district court realized that there's going to be literally hundreds and possibly thousands of these hearings over and over and over again, they consolidated all of them into one case before one judge, and then his decision was applicable to the entire Commonwealth.
Briefly, what is a Daubert-Lanigan motion?
Go ahead.
Well, a Daubert-Lanigan motion is one where, anytime the government wants to use scientific evidence against a defendant, there has to be a preliminary determination that that evidence is reliable. And so Daubert-Lanigan stands for the proposition that, we as defendants could challenge prior to trial the admissibility of a test result. And so the government then bears the burden of demonstrating that the technology, in this case the breath test result, is reliable and consistent with the scientific community.
By way of an example, they've done that with DNA evidence, they've done that with trace evidence, they've done that with fingerprint evidence, they've done that with polygraph, and that's an example of something where the courts have decided polygraph evidence is not scientifically reliable.
Right.
That's why you don't see polygraphs used in courtrooms, but that's why you do see DNA, fingerprint, trace evidence used in courtrooms, because they have established the scientific reliability of those methods.
So when this new technology comes out, we're talking about a challenge to that technology that pretty much takes place, and then we're able to move on from there.
Once the reliability and the acceptability within a scientific community has been established for any particular evidence, in this case a breathalyzer, then it would be admissible in a courtroom. And the Draeger device is new technology in terms of what we've seen in Massachusetts. It's certainly not something you see in New Hampshire. It uses an infrared light sensor to measure alcohol, and at the same time it uses a fuel cell to measure alcohol, and those two different sensors have to have a certain tolerance parameter between the two. But that's the hailing card, I guess, of Draeger's, that they use these two separate technologies, and therefore the machine is that much better than any other machine that doesn't use both of those sensors. And it's never been established whether that is a scientifically reliable protocol. And then the software, the procedures behind it, all of that was challenged as well.
So a number of challenges come down the pike after Camblin, and we deal now with thousands of, or hundreds or thousands of motions. How does the Commonwealth respond to that, specifically the court system?
Well, the Chief Justice of the District Court in Massachusetts, Chief Justice Dawley, sent out an order where, as Mike had referenced, all of the cases were ordered consolidated for one large-scale hearing that ultimately took place in the Concord District Court before Judge Robert Brennan. At the time, there was an issue as to what defense attorneys would be representing the entire class. I don't know that anyone particularly wanted to jump up to the table and take on that task,
yeah.
But there was several of us throughout the state who, take an interest in this and practice primarily in this area of law. So I think it was sort of left upon us to sort of, pursue the matter. The attorney Joseph Bernard out in Springfield, attorney Jay Milligan down in Plymouth, I believe is his office.
Yeah,
Norwell.
South Shore.
Mike and I and attorney Greg Oberhauser in Lowell were initially appointed as the 5 lead consultants to represent the interests of the defendants throughout the district court. At the same time, there was a similar litigation taking place in the Boston Municipal Court, which is, for reasons I can't explain, sort of a separate judicial system onto its own. And as both of those litigants were sort of working up to a hearing, it only seemed to make sense to once again consolidate those two actions into one large-scale hearing that, as I said, took place in Concord.
Okay, so they took place in Concord before Judge Brennan, correct? And how long did all that take place?
Well, the hearings themselves, I think, lasted about 2 weeks of evidentiary hearings. The process leading up to those hearings took about 2 years of painstaking discovery requests.
And appeals.
And appeals. And the issue really, Chris, was the scope of the hearing that was to be held in Concord. Initially, the Commonwealth, the district attorney's offices were attempting to limit the scope of that hearing so that it dealt only with the source code of the machine.
Saying that was the issue of the reliability.
That's right, that's right. And obviously, from our perspective, and I think rightfully so, there are a lot of other issues that contribute to the reliability of the test result. And so it took a lot to get the court to expand on the scope of the hearing, but ultimately we were able to do so. And we were also able to get access to some of the breathalyzer machines so that experts from the defense could test them independently.
Now that was unheard of before that.
It really was. It's something that, to my knowledge, has never been done before. And the manufacturer of this machine, a Draeger Corporation out of Germany, obviously has proprietary interests in their technology, and they're very protective of that, as one might imagine. And so it was difficult to get access to that information. But ultimately, the court determined that the defendant's right to access that information outweighed their privacy interests in that information. So we were able to get access to it, and that expanded the scope of the hearing before Judge Brennan greatly.
And ironically, one of the issues that came out of the hearing was one of the most important issues that came out, Judge Brennan found that prior to September 15th of 2014, the Office of Alcohol Testing, which is the state agency, which is part of the State Police Crime Lab, they're charged with maintaining, calibrating, and keeping all of these machines in good repair and online. He found that a lack of policies and procedures on their part rendered their workings scientifically unreliable, to the point where he ruled any test done on a machine prior to that date or done on a machine calibrated by OAT prior to that date was presumptively excluded. And ironically, that was one of the areas, protocols and procedures within that state agency that the government didn't want to get into. They wanted to keep it focused on the software and the software only, and where the defense really made the most headway was on one of those other areas.
And that was Judge Brennan's decision benefited the defense bar in that respect for those machines that had been calibrated prior to.
Depending on what county you're in.
Depending on what county, we'll talk about that in a second. What were some of the other issues that were allowed to be litigated in this hearing?
Interfering substances, and whether there was specificity with the machine in terms of being able to identify alcohol in and of itself apart from other possible interfering substances. So there were experts that testified for both the defense and for the government on the ability of the Draeger 9510 to pick up interfering substances. There were challenges to the software, the protocols, and I don't know.
There was a challenge to, I guess, the basic scientific principles behind breath testing in general. The breath testing is premised on the notion that there's a sort of a correlation.
Blood to breath.
Breath to blood, and it's premised on the notion that there's, a
Partition
set
ratio.
partition between what's in a person's, what they call deep lung air, and also in their blood. And recently there's been a lot of scientific literature to indicate that that correlation may not be exact. In fact, I think it's been well demonstrated that it's not exact. And so the question then becomes, how did those variances affect the overall reliability of the testing process?
Right.
And so this was all part of the hearings that took place over the course of how long?
2 weeks.
2 weeks.
Yeah.
Okay. And how many witnesses?
There were at least 8 or 9.
Yeah, it was actually pretty fascinating. They flew in scientists from Germany who were instrumental in designing the machine and designing the software that runs the machine in support of their efforts to demonstrate the reliability of the machine. The Commonwealth of Massachusetts called as a witness a world-famous scientist from Sweden whose name escapes me.
A.W. Jones.
A.W. Jones.
He's published over, I believe, well over 200 articles on just alcohol physiology within the body. He's like the world's most recognized toxicologist / expert on alcohol. He's in,
Really?
he testified in the hearing as well.
Yeah,
Wow.
fascinating witness.
Yeah.
Yeah.
I understand part of the problem was that when we were challenging the source code had to be translated into German and then from German into English.
Well, there were certain entries in the code
Yeah.
done by the programmers themselves that were in German that had to be translated.
Wow.
Yeah.
So let's talk about the discovery process. And that was a bit of contention between the parties, is that right?
Yeah, the biggest issue, the reason the two groups, there was one group of consolidated litigants, which was every county in Massachusetts. Steve and I were part of the group representing those counties, and then there was Suffolk County. And ironically, we were asking Judge Brennan in Concord to order or allow us to have access to 2 machines, doing dynamic, this is the big thing, dynamic versus static testing of the software. In a static testing, you take the software, you put it on a thumb drive, you put it on a laptop or a hard drive, and you go through it line by line by line, and you look for errors or problems. In dynamic testing, you run that same software through the machine as it would be run in an operational sense and stress it and test it that way. And that's considered to be the gold standard of any software analysis. We weren't getting the machines in our group. And then ironically, down in Boston, another judge in Suffolk County was going to give the defense the 2 machines.
Oh.
And we were left with the thought that, well, we're going to be playing checkers out here in Concord, and they're going to
they're
be playing
playing
chess down in Boston. And actually, Steve and I wrote the brief, that the 211-3, that's a single justice appeal that went up. And at the exact same time, the prosecutors in Boston were taking an appeal saying, whoa, 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 they're giving away too much information in Boston, and that's how the two groups ended up together. And we ended up getting the machines and having the ability to do the dynamic testing.
And that was as a result of your appeal?
Our appeal, their appeal, and then Judge Botsford, who's now retired, but she saw us a couple of times on appeals, and she was the one who said the two groups will be joined, they will have access to two machines, they will be allowed to do dynamic testing, and then she allowed on another appeal more time to really get it done correctly and properly before it was finally litigated.
Now, as part of examining some of these machines, did you discover some issues?
I was not part of that. The two of the machines were out at another location. Joe Bernard did a lot of that work. They found that the machines had some inability to pick up certain interfering substances, but then you had someone like A.W. Jones come in and say that those substances to be present at a level to be detectable would be fatal. And so there was there was a lot of back and forth about what the machines can and cannot do. I think ultimately, the decision is that they do act as designed. They can do what they're supposed to do, but what they don't account for are the individual differences in partition ratio from one person to the next, and whether that's fair or not fair. But ultimately, I think the technology is not awful. And what we found out is that the machines are pretty much only as good as the people that design them, maintain them, calibrate them, and use them.
I think it's one thing I think is important to stress. There's a distinction between the admissibility of the test result and then the reliability of the test result. So the Daubert-Lanigan challenge that was raised,
Kind of a gateway function.
this is really sort of a gateway thing to see whether it meets that preliminary threshold of reliability. It doesn't mean that the test result is 100% accurate or there aren't potential defenses to that.
And that can be challenged at trial.
Correct.
It's good enough for government work. It's good enough for a prosecution. It's
Sure.
reliable to the extent you can use it.
And then you just test it in before the jury? Or
Right, whether it's proof
at
beyond a
trial.
reasonable doubt is another thing.
So Judge Brennan's decision was to allow in presumptively certain breathalyzer results, presumptively exclude certain breathalyzer results. What was that based on?
It was not based on interferent substances. It was not based on any software glitches or problems. It was based exclusively on the fact that he found that OAT, Office of Alcohol Testing, prior to September 15th of 2014, did not calibrate annually and maintain annually these machines in a scientifically reliable manner. Meaning, OAT is a calibration laboratory. They take in devices, and these are measurement devices, and therefore they have to be calibrated in a scientific manner to be reliable and put back into the field. And they were basically operating without written protocols. How does a scientist, whether the scientist be you or Steve or I, take a machine into the laboratory every year and calibrate it? And there was testimony that they did it by kind of word of mouth. We figured it out, and kind of by word of mouth we told each other and instructed each other and looked over each other's shoulders to make sure that we were doing it in a good way. Well, where was the documentation of that procedure? It didn't exist before that date.
That wasn't good enough.
No, he found that that was not a scientifically reliable way to run a calibration laboratory. And that's where he set that date. After that date, OAT has been building up protocols and written procedures, and they got to a point in 2014 where they finally had established a reliable written protocol for calibration annually.
And that written protocol went into effect in September of 2014.
Correct.
So that's the beginning, that's the
Cutoff.
the date by which if the calibration occurred before that, it's presumptively out. If the calibration occurred after that, it's presumptively in. Correct?
It was if your test, your breath test was done on a machine that was calibrated, because it's an annual calibration. So you could have a machine that was calibrated in July of 2014. So that means any test that was done from July 2014 all the way to July 2015 on that machine is presumptively excluded.
Okay.
Certainly before that date, it's excluded. But if it was done on a machine that was calibrated last before the date and then went into the next year, it was out as well. Anything done on a machine calibrated after that date is presumptively admissible.
Now, we keep using the word presumptively, which leads to where we're at this point, right?
Right. So currently, in Judge Brennan's decision, he ruled that although the tests that were presumptively inadmissible, so the older cases that were performed on machines certified prior to September of 2014. He ruled that they would be inadmissible unless the government could somehow demonstrate that they were reliable.
He had one sentence too many.
That's right, that's right. Those of us involved in the hearing thought that's what the Concord litigation was about, but apparently Judge Brennan had other issues. So the bottom line is, even though those older tests are presumptively inadmissible, he left some wiggle room where the government can attempt to sort of revive those tests by demonstrating on an individual basis that the individual machines were certified in a proper fashion.
Even though a protocol didn't exist.
Right.
So what they're trying to do is they're trying to take the protocol that came into effect after September 15th, 2014, and say this is the proper way to do it. And on a case-by-case basis on these older tests, they'll bring in the chemist, if that chemist is still around, who calibrated that machine and say, well, did you do it this way, and this way, and this way, and this way? And therefore try to demonstrate that even though there wasn't a written procedure and protocol, they did it consistent. They did it consistent with the one that came into effect later, therefore it is reliable. So in some counties, and this is really frustrating for Steve and I, because he and I go all over the Commonwealth, and we were just talking about Barnstable, Plymouth, Hampden, Worcester, Middlesex, Essex, Norfolk. Middlesex County, they're trying to get him in that way. Essex County, they're trying to get him in that way. Norfolk County, they're making the effort. Plymouth, they are not. Barnstable, they're not. Worcester, they have absolutely not tried to do it. Hampden, they have not tried to do it. So depending, which is frustrating, because if you have a case where you're representing in people in many, or you have cases in many different counties, you're getting different justice in different counties.
And the problem with that, Chris, is that the whole consolidation was designed to avoid just that scenario in the first place.
Right.
So we would have to do it over and over and over again.
That's right. That's right. The district court ordered that consolidation initially because, as Mike said, they didn't want to have a situation where we have 1,000 different hearings on the same issue
It was
in the
supposed to be
various
more
courts.
efficient.
Right.
Yeah.
And now, 2 years after the fact, we're being thrust back in the position where we're having these many little hearings in the various district courts throughout the Commonwealth, depending on whether or not the Commonwealth wants to try to revive those tests.
With different decisions, even within the same county.
Right.
Sure.
We have different decisions in Middlesex County from Lowell, Concord, Natick, just different judges looking at the same issue, deciding differently.
Which
So,
is again,
even within the same
what
county.
was to be avoided with
Right.
with the consolidation.
One decision applicable to the entire Commonwealth to save the resources, the time, the energy, the money involved in litigating this issue over and over and over again. And that one sentence by Judge Brennan gave the government the ability to basically, on a case-by-case basis, try to do it all over again.
And you mentioned time. The people whose cases these are affecting still have their lives on hold.
I had
correct?
two this week, my two trials this week on Monday and Tuesday. One was December of 2012, and the other one was July of 2012. That's how long. Now, some of these cases had to do with an earlier appeal, Cormier, but there are cases that have been hanging around 4 and 5 years to get to trial.
Yeah, I think the named defendant in the litigation is a client of mine, and that case dates back to 2012, early 2012.
Wow. Wow. Okay, so that's dealing with the cases that were presumptively excluded. We're now going back before the district court judges, and what's at issue now?
The tolerance parameter in the presumptively admissible cases is another issue that came out. As a result of the litigation in front of Judge Brennan, we
So
found
this
out.
is the other category of cases after September 2014.
Well, these apply to everyone, but these post or the presumptively admissible cases, an issue that came up is with this infrared sensor, which is the one that reports the result, and then the fuel cell sensor that basically double checks itself against that, and they have to be within a certain range. And if they're outside of that certain range, they call it the tolerance parameter, the machine is supposed to abort and say, listen, your IR, your infrared is not matching up with what the fuel cell, the EC, says it should be. And if they're not tightly tolerated, if there's not a tight parameter, the machine is supposed to abort the test.
Okay.
And the setting that they ordered from Draeger was 38 micrograms per liter. That was the tolerance parameter between the two. And we found out because they gave us the database, and one of our experts was going through and going, well, that one's wrong. That should have been aborted because it was too wide. That should have been. So we found 5 or 6 examples where the machine should have aborted because the parameter had been violated, and it didn't. Well, come to find out that those 6 machines, it wasn't set at 38, it was set at 60. And therefore the machine was less sensitive than it should have been. And Judge Brennan in his decision noted that, and he said, this is of concern, of great concern. And by the time he got his decision out to the district courts, OAT brought in Draeger, they checked 400 machines, basically every machine in the Commonwealth, and not a single machine was set up correctly.
They were all set incorrectly.
Either too tight or too wide, but none of them were set at 38. They were all set at 30 or 60, which is shocking because if we hadn't litigated the case, that would have gone undiscovered. So then they had to bring in technicians from Draeger and bring in every single machine across the Commonwealth and basically reset it and fix it. So every machine in the Commonwealth, as I would say to a jury, was broken.
Yeah.
Until this past March, when they recognized the mistake and fixed it. That's an issue that came up with the presumptively admissible cases. So that's a fix that came about as a result of this litigation.
I mean, if you think about over the 5 or 6 year period of time, the thousands and thousands of people who have taken this breath test
Sure.
that was not even designed or set up to manufacturer's specifications, it's very scary.
Now, what is Draeger and the Commonwealth saying about these misset machines? Were they supposed to be caught by the officer as a problem if they're off?
No, most of the machine itself is beyond the ken or the understanding of any police officer. Any police officer in a courtroom will say, if you're cross-examining them on the workings of the machine, they'll say, counsel, I just press the buttons.
Yeah.
And it's a touch screen, and that's literally, they do some input on a keyboard, and they just press the buttons. How the machine actually works is really beyond the understanding, I think, of most police officers. And they wouldn't recognize that this tolerance parameter was wrong.
So again, it's up to the experts.
It is kind of ironic, though, Chris, as Mike had alluded to earlier, one of the design features of that machine is the fact that it has this EC
Dual cell.
reading, dual cell technology, so it can compare the test results with. Our law doesn't require that. It only requires the infrared reading. And so when the problem with the tolerance parameters was discovered, the government's position was, well, that only affects the fuel cell reading. That's not required, so it's kind of no harm, no foul. Even though it's that dual sensor technology that's supposed to make the machine so reliable.
Sure. Well, unfortunately, that's all the time we have. I think we could keep going on as this litigation will
check back with
continue.
us in 3 years.
But I want to thank you both for coming and talking to us about the current state of the breathalyzer and the breathalyzer challenges to the 9510. And thank you, folks, for your attention. As always, I tell you, don't take as advice anything that we're saying here. With your own individual cases, you should be going to local counsel, such as Mike, such as Steve, to talk with them about your individual situation. Talk to local counsel. That's what they're there for. On behalf of Michael Bowser, Stephen Valancourt, I'm Christopher Lilly. Good night and thank you.
Thank you.